All right, folks, welcome back. And you could tell by the open, it's time for Kendall Coffey and Spinning the Law, founding member, of course, of Coffey Burlington. And he is with us. Hello, Kendall.
Hey, Steve. Thanks so much for having me on today.
It is my pleasure. All right, let me ask you this question, because I've been bringing it up, and I'm dying to get the legal answer and not my, phony legal opinion. Eric Holder, Attorney General of the United States. Now, we've heard the president talk about the case in Ferguson and say, I have to watch what I say. He didn't do that necessarily with Trayvon Martin, and he didn't do it with the Cambridge incident, but he did in this instance. So Eric Holder goes down there, and Eric Holder is talking about how this is personal for him. It's not necessarily about the law, it's personal for him. And then he brings up his own situation and history where he claims he was stopped on the New Jersey Turnpike for no reason, etc. Is that, and this is on the eve or the day that the grand jury is convening, is this prejudicing, if that's the word, this case at all? Could a lawyer at trial eventually bring up what the Attorney General said at all, or am I just in fantasy land?
Well, I think it could certainly contribute to a view that the flames are being fanned of pretrial publicity. And that can be an issue that gets down the road into venue changes or things like this. But we all have to recognize that this is an extraordinary thing for the United States Attorney General to go onto the scene of an investigation of its early stages. It's very hard to recall that. I can think of maybe one in recent years where Attorney General Holder was down early dealing with BP, but just as a general matter, this hardly ever happens. What does it do? I think in the Attorney General's mind, perhaps it's going to calm the community down. But let me tell you a couple things it does. Necessarily, it's going to put more pressure on prosecutors and FBI agents, because they're going to perceive that the guy at the top wants some action. So I think that's a legitimate concern. It's going to create community expectations, because I think in Holder's mind, he wants a fair, objective investigation. I certainly hope so. And if the community, after seeing him come there and hearing these remarks, does not see a federal investigation, I think there's going to be huge disappointment. And the other side of it is from the standpoint of the police community, which is rallying behind Officer Darren Wilson. Make no mistake about it. They now see an attorney general who is indicating some degree of unusual personal interest and personal investment in investigation. So if there's a federal prosecution actually brought, there's going to be a concern on that side that this thing was not as fairly and objectively considered as it should have been. And we all need to bear in mind that as much as this case is a cause for family and friends and supporters of Michael Brown, this is a very big cause, perhaps even a national cause, for the police community, which I think largely believes that the officer is being scapegoated. And those concerns are certainly not softened by the high-profile presence of the nation's highest-ranking law enforcement officer.
Those are all great points. And the scariest, I guess, is the high expectations, because if an indictment is not handed down, then I don't want to see what militarization the police might have to pull out once again.
Yeah, and I don't think the Attorney General intends to stack the deck. I'm sure he's telling his prosecutors and his FBI agents, be objective.
Young man whose name escapes me, Darian Johnson, I think he was in the store with Michael Brown when the robbery occurred, or as Al Sharpton defined it, attorney Al Sharpton, shoplifting. It's not robbery, it's shoplifting. By the way, he's wrong about that, isn't he? I mean, the police called it strong arm robbery, yet he said, let's be real, it's shoplifting. Is there a legal difference there?
Yeah, shoplifting involves a theft where there's no confrontation at all. You walk into a store, nobody's looking, you grab stuff and
Right.
you walk out. That's shoplifting.
Well, we saw a confrontation.
Robbery
yeah.
means that you take from another person by varying degrees of coercion or force. It can be obviously we've all heard of armed robbery. That means
Right.
that the theft is accomplished by pointing some kind of weapon at the victim of the thievery. So there is a difference.
Yeah, and we saw the Michael Brown video where he pushed on a couple of occasions the store owner who went after him. So I would assume that's more like robbery than shoplifting, correct?
Well, I think police, if there's a physical confrontation that's part of the theft, police would be more likely to charge that as a form of robbery.
Yeah, as they have. And I got sidetracked. I sidetracked myself, so I kind of lost my train of thought on where I was going with that. But you know, I had Jesse Jackson on the show, and I gave the cop side of the story, really, and said, what if? And what if the cop was, the door was pushed on him, and he was punched, and they grabbed for his gun, and it went off, and then the guy runs, and then he starts coming back and starts charging at the cop, and the cop fires until the guy stops because he thought, you hit me once, he dazed me a little, I'm in fear for my life. First, he accused me of giving a worst-case scenario, and then I said, but if it were true, I said, are there any circumstances under which the cop would be justified in shooting Michael Brown? And he said no. Now, that is legally and ridiculously wrong, correct?
Well, you've described it as a worst, it was described as a worst-case scenario.
Right.
Actually, that's the narrative of Officer Wilson,
Right.
I understand. And that's the version of the facts that the local police believe and is resonating throughout police communities in this country. We don't know what actually happened. But if a jury were to get this someday, and he may never be arrested or prosecuted. We're all getting ahead of ourselves to talk about what happens if there is a prosecution. But if a jury believed that there had been a felony perpetrated on the officer, and let's start out with that for a minute because it sounds technical, but it can be important. That is to say, an officer's gun is grabbed in the course of a physical alteration with a suspect. And then, after briefly attempting to retreat, that same suspect comes back charging with the officer. And despite the officer saying stop or telling him what to do, it's ignored, and he's coming right on top of the officer. In that case, I think a jury's going to have, if the jury, accepts that narrative, it's going to create a reasonable doubt as to whether excessive force was reasonably necessary, and there could very well be an acquittal in that scenario. It's going to. The other thing about the scenario I just described, and you'll see some technical arguments about this, is that if, and again, all this is if, Steve. We don't know what really
absolutely.
happened. We know eyewitnesses disagree,
right?
And who knows? Maybe there will be disagreement among them.
Right. No, we're going on the cop's narrative, and if it were true, yeah.
But let's accept what we think is a police officer's narrative. Whether or not what occurred in the convenience store was a misdemeanor, whether it was strong-arm robbery, whatever you want to call that alleged theft, grabbing a police officer's gun and struggling physically with a police officer is a felony by itself. So at that point, the officer could certainly argue that there was probable cause to believe that he was dealing with, in effect, a violent felon. So that's a part of this that's also going to play out in terms of the legal tests for excessive force.
Well, that's what I want to ask you, Kendall. Not to interrupt, but we have 2 minutes left, and I meant this is it. The fleeing felon law or rule. When the debate was that the cop drove up, knew and thought that Michael Brown was a suspect in the robbery, and he ran, I heard lawyers on TV say he had a right to shoot him as he ran because he would have believed he was a fleeing felon. But forget the robbery now. What if just he got punched by this guy and the guy grabbed for his gun and it went off and then he runs? Is that a fleeing felon? And does he have a right to say stop, stop? And if he doesn't, does he have a right to shoot him as he's fleeing?
Well, in the scenario, and I'll try to speak fast, where all you know is that somebody stole something from a convenience store, you don't know whether there was a violent act.
No, forget that.
Or
just
not.
the experience with him, just the hitting him in the eye and the grabbing for the gun. Is that enough?
Right. Now, under the constitutional standard, that may well be enough because now you're stopping the escape of somebody that you have probable cause to believe is a violent felon.
Gotcha.
And that is why I think that part of the officer's narrative is going to get more important as this case evolves.
Gotcha. Very good. I didn't mean to put you on the spot. You did it very well and very thorough. I didn't mean to give you a short shrift on that. Kendall, great talking to you. You answered a lot of my questions, and I thank you very much. Always a pleasure.
Hey, thanks for having me on.
My pleasure. Kendall Coffey, ladies and gentlemen. By the way, Spinning the Law is not just the name of the segment, it's the name of his book. I say that every week. It's been many years, 4 years, 5 years since the book's been out. Find it. It is amazing, the cases that Kendall's been involved in and cases that have affected the United States of America very, very strongly. All right, before we go, we want your opinion. Is Rand Paul right? Do you think the Ferguson police are militarized? Go to newsmax.com/polls and give us your vote. Newsmax.com/polls. Do you believe the Ferguson police are over-militarized? You know what's next? We call it Gimme 5. Don't miss it.